Proposition 209. Unfortunately, that campaign failed, and Prop 16 didn't pass, and Prop 209 still exists. But my point is that this is my field of study. I intimately understand Proposition 2. This is not guesswork for me. This is my work. So I'm going to talk to you today as a civil rights lawyer and as a legal scholar who understands Proposition 209, the challenges to affirmative action, and the 13th and 14th Amendment. So the first false argument here is that, oh, we can't do any, we have to do lineage-based because we'll never get past Proposition 209 if we're not lineage-based. You must understand, and I tried to make this clear through the testimony of Professor Chemerinsky, Proposition 209 only applies to state education, the state contracting, and state employment. If we legislate on any other grounds, so if we talk about giving tax credits to people of color, or if we talk about doing land reparations, or if we talk about changes in the healthcare system to protect African Americans, none of that implicates Proposition. Okay? So we need to stop adhering to this argument that we have to be lineage based because Proposition 209 will defeat any race-based claims. The other really important thing to understand about the 14th Amendment is that the court, including the federal courts, and I've read all of the cases because I have to use them in my litigation on it, the court will allow for race-based claims. There's a complete misunderstanding of the law here, saying you can't have any race-based claims. That is incorrect. The court will allow for race-based claims, but you have to be able to show that those claims deal with contemporary harms and future harms, and that they are not remediating past harms. So from a legal perspective, a purely legal, scholarly, and constitutional perspective, we are going in absolutely the wrong direction if we focus only on the harm of slavery, because the court will not recognize or countenance that. That is a past-based harm. So we must make sure we include present-day harms and future harm. And that's based on domestic law. And that actually is contiguous with international law, which says that one of the critical tenets of reparations is that we have guarantees of non-repetition. Reparations from an international human rights perspective is present, looks at the present, and it looks at the future. And it says you must abate the harm. You must stop the racism. That is reparations. You do not use the term reparations if you are not prepared to do that. And the system that folks are advocating here, where we're going to splice things up and have this specificity where only one small slice of the Black population is being remediated, that will not abate the harm of racism. That is not reparations from an international human rights perspective. I'm going to say one other thing because I'm trying to really focus in on the legal perspective because I feel like I have the qualifications being a 20-year civil rights lawyer, a graduate of NYU Law School. I'm going to talk a little bit about legal intent and statutory intent, rather. We're hearing constant refrain that, oh, the statutory intent, we can't do it because the statute is very, very narrowly defined based on incorrect. Again, first of all, you don't even go to statutory intent unless the language of the statute is ambiguous. The language of this statute says African Americans with a special consideration for descendants of people enslaved in the United States. You look at the common parlance. You interpret the language of the statute based on the common understanding of the words. African American, the common understanding of the term African American means Black people, all Black people. All right. And so the actual language of the statute is not ambiguous. We don't even need to get to the legislative intent. We have unambiguous language that is broad, that says that we can create remedies for African Americans with a special consideration for descendants of U.S. slavery. All right. So let's not get bound up in legislative intent at this point, because we don't have ambiguous language. And the last thing I will say about legislative intent is that the clear intent of this legislation is that we, the 9 of us, who are all experts and scholars in our own right and all champions of racial justice for decades, it is our task to take 2 years to listen to the evidence. And based on that evidence, we are to make recommendations. That task was assigned to us. And so that is what we're supposed to be doing here, listening to all of the evidence and crafting solutions based on all of that evidence. And we can take 2 years to do it. We don't have to do it in 6 months. So ultimately, we have the discretion to decide based on the evidence that we have marshaled what this legislation and what these recommendations should look like. And they can be broader than any sort of limiting language that people are citing to in the statute. We have the discretion to broaden it. And from a legal scholar's perspective, that is how legislative intent works.
Thank you, Member Holder. Any other members who'd like to contribute to the discussion on the motion of the floor? Member Bradford, I saw your hand. You're recognized.
I will yield to Dr. Grills, please, and then I'll go after that.
Okay. Member Grills, you're recognized.
Thank you. And I want to thank Member Holder. She addressed some of the things that I had concerns about. So I'm just going to try to share an overall observation and then just kind of address in a sentence or so a couple of things that I heard from the witnesses or in our discussions today and prior to today. I want to start with what I consider to be an irony. Europe and the United States concocted this thing called race to define and control us. And now we find ourselves being restricted from using the very thing they concocted to liberate ourselves from the legacy of the systems of oppression that they created. And I think that Member Holder has shown us a legal pathway to get around what may have been an attempt to restrict us. In addition to that, my interpretation of AB 3121, using the words in the legislation, is that we must address remedy for enslavement and its legacies. And in those legacies, all Black people are impacted. And I'm going to come back to that with not armchair theory, without a personal experience, but grounded in some data. But let me say first that lineage-based approaches are in fact divisive of a Black community that we need to be united. In addition, it has the potential to exclude folks who have the lineage, and it does not address the greater harms for those folks whose Black skin relegates them to the same forms of racism as those of us who are US-born descendants. Now, I am a descendant of enslaved Africans, and I understand my responsibility to my ancestors, but I also understand the larger picture and the responsibility to a much broader global process that Dr. Carr tried to speak to, that, existed and was launched prior to even the definition of what we now call the United States. Now, providing reparations only for those who can prove their descendancy from enslaved Africans is yet another win for white supremacy, because it dismisses and devalues the harms done to African descendants, not enslaved here, but who were injured by slavery due to their blackness once they entered the shores of America. And they're injured by the legacies of slavery due to that same blackness that we as descendants experience. And policies and practices that flow from this anti-blackness are the legacies of slavery. Now, when you talk about this legacy issue, one of the presenters talked about the genealogical proof standard. And that, I believe, adds another layer of complexity and could perhaps introduce a level of delay in dispensing reparations. And that's something that we may not intend. They named 5 things. And when you think about those 5 things, and then those who may be standing in line for reparations and all of the structures and processes that would have to be put in place, I actually couldn't figure out when we would actually get to a point where people could see real reparations. You're talking about reasonably exhaustive research, complete and accurate source citations, thorough analysis and correlation, resolution of conflicting evidence, soundly written conclusion based on the strongest evidence. That's a lot. Now, in terms of harms, I've been listening to folks who are strongly in favor of lineage-based, and I've been listening carefully to their arguments about why we should not include people of Caribbean or African migration status, right? There's a lot of things that they say, but I don't see it backed up by any actual real data. So, for example, people say they do better than we do on most markers of social advancement. Well, there is a study that actually looked at that issue. And what they found was that it is not a Black immigrant issue. It is an immigrant issue or dynamic that is at play. That when you look at immigrant groups from across different racial and ethnic classifications, they tend to do better, having something to do with our U.S. policies on who gets in, on the psychology of immigration, and this notion of trying to, do better than the circumstances that I was fleeing from or needing to depart from. So I think, we need to get a little bit more nuance about how we are characterizing our immigrant family members and ground it in some real data, not in, well, my experience was this, and well, my experience was that. Well, I know people who did this, that, or the other thing. And in terms of the harms to Black people, no matter where our ancestors were in 1870 and before, findings suggest, based on studies, that despite potentially experiencing high rates of discriminatory and or racist behaviors, African origin Black immigrants' health does have some deterioration. And in fact, to quote one of the articles, they said, as time spent within the United States increases, health correspondingly deteriorates and converges with that of the referent US-born Blacks. Now, the findings presented here in this study and several others provide further insight into the health of African origin Black immigrants, which is a rapidly growing proportion of both the US Black and foreign-born population. And last time I checked, once you become a citizen, you're a citizen. And so what they're experiencing matters, right? There's a positive correlation between, again, duration in the US and the health of Black immigrants to the US. And again, that is based on the fact that they are experiencing the harm associated with the legacy of enslavement. And this is, again, based on the research of people who conducted a study on the Immigrant Health Advantage, which was an examination of African origin Black immigrants in the US with a sample of 570,675 adults aged 18 to 85 from the 2000 to 2018 National Health Interview Survey. In at least 6 other studies, sitting here right now on my desk, for Black immigrants adopting a Black racial identity, it often leads to a downward rather than an upward mobility for them. So this notion that they are doing so much better and they came of their own accord, that needs to be interrogated. Further, Black individuals living in the US, including Black immigrants who experience race-related stress, are vulnerable to psychological distress in the form of depressive symptoms, such as feelings of sadness, hopelessness, and worthlessness. As a clinical psychologist, I actually had clients who were African immigrants and who were Caribbean immigrants, and they were struggling under the weight of American racism. They did not understand or know the extent of that racism. I could also go into research that addresses some of the concerns that people have raised about African immigrants don't want to connect with African Americans. There's a whole literature on that with data to support it. And I have to say that the comments that I've heard to date do not reflect that. So lastly, I just want to say, in terms of some additional comments to things that I've heard, Queen Mother Moore was invoked today. And I just want to say that having talked to people who studied under or mentored by, sat at the feet of Queen Mother Moore, they are very clear she was a staunch Pan-Africanist. And in fact, her first organization was called Ethiopian Women. I could go on, but I'm going to stop here just in the service of time. I do want people to finally know I am not against addressing the primacy of the needs of those of us who are direct descendants. I am, in fact, in favor of what the language was saying, showing special consideration. And I think that part of our job is to figure out in our future meetings what that special consideration looks like. But I don't think special consideration is the same as, and therefore deny everyone else. Thank you.
Discussion motion on the floor. Member Bradford, nice at this time.
Thank you. I appreciate it. And I want to thank Barrister Holder for that clarity on 209 and that brilliant presentation as even explaining the Constitution. I'm not a lawyer, nor do I play one on TV. So thank you for your expert testimony right there. My question would be directed to Barrister Holder. Understanding your description and who falls in this category, and kind of like parallels where Dr. Grills is, does Dr. Scott Lewis motion capture the intent of who needs to be included here?
Can you hear me?
No, now we can.
Okay. As I said, when you're looking at legislation from a legal perspective, the first thing that you're supposed to look at is the language of the legislation itself. And if the language is unambiguous, you stop there. And so language that says African Americans with a special consideration for descendants of U.S. slavery, in common parlance, that's very clear. African Americans, that means all Black people. And that's where you start. You start with the broad category of all Black people. And then you go to special consideration for descendants of enslaved people born in the United States. The language is clear. You don't need to go beyond the language. And that is how we should be proceeding. That is how we should be framing any motions. And again, because we, the 9 of us, are charged with studying this issue, we have the discretion to interpret that language in the way that we see fit, consistent with the expert testimony that we are seeing.
So should there be a gradation, so to speak, a step down of levels of reparations? I mean, if we started with direct descendants and then those who are directly impacted or have been impacted, does it not capture, that sliding scale of people who need to be included? And, there's been discussion about, as Dr. Scott Lewis says, we'll get into the weeds of what it looks like later on once we define who gets it. But I want to use as an example, like first-time home buyer. I mean, if someone in your family has bought a home before, I don't think you should qualify for a first-time home buyer. But if you're 3 generation, 4 generation living in housing projects, which there are many African Americans who've been 4 and 5 generations in public housing, they're the ones should be in the front of the line for, I think, housing assistance or first-time homebuyer programs if we're doing reparations. Would someone like that qualify? I mean, I think that's what we should do, even when we talk about education opportunities. You're the first one in your family to go to college. Those are the ones that should be entitled. But I don't want to get into the weeds. I really just want to see how we capture what Dr. Weber's intent was, truly direct lineage, but also open up the paradigm, because you've all articulated so well the long-term impacts of slavery and its ongoing effects here in California and America. So I just want to know if our motion captures that, and if, again, are we leaving people out with what? Because I like what Dr. Scott Lewis stated: direct descendants and anyone who arrived in the country prior to the 19th century. So I think that captures a lot of folks that was discussed today. So that's my only comment or question.
Yeah, I think the motion is crafted in a way that is still narrower than the plain language of the statute. And I think that I think the plain language of the statute is quite broad, and there's no reason to go narrower than the plain language. I think the plain language is African Americans, meaning all Black people, with a special consideration for descendants of U.S. slavery. And so I think Member Scott Lewis's language is still a little bit too narrow. And again, I will echo Professor Grills here. I do agree that there should be special consideration for people descended from U.S. slavery. I think that they should get primacy, and that's written into the motion. But that does not mean that we exclude everyone else. I think Member Tamaki has his hand up.
I'll defer to Professor Lewis if you have a comment, Siobhan.
Just a brief comment. Thank you so much, Don.
Yep.
I just want to draw attention to AB 3121, where it says that the purpose of this chapter is to establish a task force that would do all of the following. 1 is study and develop reparations proposals for African Americans as a result of. And following 1A, B, C, D, E, and F, right? Well, E, up to E, all reference slavery in this country. And then F talks about the direct benefits to societal institutions, public and private, including higher education, corporate, religious, and associational. 2 is to recommend appropriate ways to educate the California public of the task force's finding. Right? And then 3 is to find appropriate remedies. So my view is that with the bill, when it states what the job of the task force is, every single statement about what our role is references slavery. And I wasn't there when the bill was written. But if you're going to tell me that all of the tasks, again, 1A, B, C, D, E, and F, reference slavery, must be responsive to the experience of slavery, then that, to me, very clearly delimits the scope of who we're talking about. Thank you for the time, Don.
Thank you. Maybe, Professor Lewis, I can just jump off from what you just said. I just want to frame my remarks with the obvious. I'm the only non-Black person on the task force. So I really want to approach this with deep humility and appropriate utmost respect, knowing very well that this is a personal issue. And it's not just about the compensation or the reparations. It's about a group's identity. And that's why I think it stirs, such heartfelt emotions from everybody. I also want to say there's no pure way of remedying this issue or answering the issue. And having gone through the Japanese American reparations movement in the 1980s and was involved in the litigation connected to that in reopening Korematsu versus the United States, which, was the notorious Supreme Court decision legalizing the rounding up of American citizens who happen to look like the enemy. I think I know a little bit about the divisions that can happen. We experience this too. And the reason why I say it's not a perfect remedy, this is rough justice, because at the end of the day, we had to exclude groups also within our own community. And among them, for instance, if you weren't living at the time that the legislation passed, you didn't get any reparations. Does that go to a person's identity to the group? Absolutely. Does it hurt? Absolutely. Could the bill have passed with something more? Probably not. So some practical, very difficult, decisions were made, and we're feeling the same way on this task force. So I'm not going to talk about lineage or legislative intent and the legal side of it. I think that's been fully covered by the other speakers. What I'm really turning to is the practical impact that we've got to provide guidance to the economists, bottom line, as a starting point, I would say. And in terms of how they measure the harm, they need to know who the community of eligibility is. So as I view or in hear Professor Lewis's comment, it provides at least a framework, and then within that, the task force can evolve and move on to all of the remedies that constitute reparations. So in my mind, there's a couple buckets here. I mean, a principal primary bucket is recognizing the victims of a harm that happened in America. And it is specific, and it is a specific class of victims and people. And, it goes to the question of disaggregation and identifying the differences within an ethnic group. And for that particular harm, there has to be a focus. So to that degree, I appreciate what Professor Lewis is doing. And I think from the comments of everybody in the task force, I sense that particular harm class has to be addressed. But there is another bucket, and that is the other principal precept of reparations, which is cessation of the harm. It's guarantee of non-repetition. And some of those, I'd say 75% of that harm is talked about and described in excruciating detail in our 600-page part 1 of the report. It goes into housing, it goes into education, it goes into criminal justice, it goes into mass incarceration. And those things aren't neatly differentiated by lineage. And so, not that lineage is not important, but to me, lineage is just the tool or the mechanism that you get to identify the harm party. And lineage has its difficulties. Some people will be able to prove right to the very beginning. Others may not be able to get past 2 or 3 generations, or may not get past the 1940s. And so I think if we still nevertheless approve the concept that we need to recognize the harm group, and these are the descendants of American slavery, and then wrestle in the months to follow with how that's proved. And lineage may be one way, negative inference may be another, where if it's impossible to prove a lineage, then there may be other ways of demonstrating the connection. So that is basically one bucket. And with respect to that kind of reparations, in my view, in my humble opinion, I haven't ruled anything out. It's all on the table in terms of forms of compensation and remedies. But I think we're also tasked with addressing ceasing the harm and guaranteeing non-repetition. For example, Lisa Holder and I are working with the Department of Justice on a survey that courts and 58 district attorneys in those counties would have to respond to, tracking how the racial data in connection with whether Black defendants are charged and sentenced as severely as white defendants for the same crime. That's not a descendancy issue. That is a bias issue. That is a anti-Blackness issue. And to echo Camila Chair Moore, I think these things are not mutually exclusive. We can address a specifically harmed class that Professor Scott Lewis has talked about in his resolution, but we can also work on policies and actions to implement a guarantee of non-repetition, which is all this other stuff. So I don't see them as mutually exclusive. I see them as different facets of the same horrific problem that we're dealing with. So I realize that's an outside observation of someone who's not a member of the Black community, but I think it's a bit informed because we've gone through some of this in my own community. And I realize how deeply personal this is. And believe me, we felt the same way in connection with our reparations issue also. So I really appreciate the comments on all sides, but I would urge us that we have to move forward. We have to give guidance to the economists, let the economists do their metrics and measurement, and let's branch out from there, including, if you can't prove lineage, for example, how else can we do this? There's got to be other ways to recognize and acknowledge, an unacknowledged harm class of people, and also dealing with issues of ongoing discrimination in employment, housing, labor, environment, criminal justice, opportunities, everything else. That's all. Thank you.
Chair Moore, I just have a quick comment.
Yes, Member Holder, you're recognized.
Thank you. The economists did send us a document where they laid out certain parameters. And when I reviewed that document, I noticed that they indicated that there are 2.6 million Black people in California. So they know that number. They have that number. And of those 2.6 million Black people, 2 million are, for lack of a better word, likely descendants of U.S. enslaved people. The other 600,000 are descendants, perhaps, of people who were enslaved outside of the United States. But we know that we have a constituency of 2.6 million. And what I propose is that at this point, we keep that number. That's the number that we allow the economists to use as their benchmark. You say there's 2.6 million Black Californians. Use that to make your calculations. rather than right off the bat excluding 20% of that number or 30 or 40% of that number. I think at this stage, we can give them the whole number of 2.6 million and have them use that as their benchmark.
Holder. Are there any other comments or questions on the motion on the floor?
If Chair Moore,
Member Jones-Sawyer, you're recognized.
and maybe because I'm not as articulate as Attorney Holder, but sometimes simplicity is the best way. And in some ways, I think we're all kind of saying the same thing, and we're all grappling with what is the best way to say, which is already there. That we make sure that the harm is ceased and stopped for African Americans, with a special consideration for descendants of slaves. And I think what I was trying to say and what the motion to the floor was trying to say, I think we're trying to get to the same place, but we may be arguing with semantics and how we want to phrase things. And so if this motion fails, hopefully we will immediately move on with African Americans with special consideration for descendants of slaves, because I think it addresses both. And then we can move on. I think that might give everyone not everything that they want, but maybe give everybody the comfort that we need to move forward and really get to the hard work of providing leadership on the recommendations for reparations.
Member Jones-Sawyer, we're not all saying the same thing. And the motion that is on the floor that was properly moved and seconded by Member Jovan Scott Lewis and Monica Montgomery Steppe is aligned with what Secretary Weber stated. In fact, and I quote, Secretary Weber said, "It's an issue not about being Black. It's an issue of descendancy and lineage," Weber said. "There will be many Black people," she said, "who do not deserve reparations. But there will be many whose lineage clearly says very strongly that they deserve to have reparations." That is what Secretary Weber said to us in January. Also, you noted something about class action lawsuits. I know you're not a lawyer, so you might not know the four components of a class action lawsuit: commonality, adequacy, typicality, right? If you don't fit, if a certain class doesn't fit into those four standards, then you're out of the class. So when we're talking about reparations for three, you're talking about people who share the commonality, adequacy, numerosity, and typicality, to the extent that Black immigrants also experience harm or anti-Black racism. Nobody on this task force has denied that. But in line with the legal dictates, you file a separate claim, just like the Japanese internment camp victims who were not American citizens, who were harmed by the same United States government in the same location, but because they were not American citizens and legal permanent residents, they had to file a separate claim. Fortunately, successful, who were able to get their reparations as well, but they had to file separately. That's what we're talking about. In terms of common parlance, Member Holder, I disagree with you. I have lived next door to a Jamaican family my entire life. Last weekend, I told him that I was a part of a reparations task force. And the first thing he says to me, are all black Californians getting it, or just, and I quote, African Americans? Because he told me, as a Jamaican, he said, I'm a Black American, but I'm not an African American, and I do not think that I'm owed reparations. I think African Americans are only owed reparations. So in terms of common parlance and colloquialism and that what you're saying is inaccurate. There is an understanding amongst Caribbeans and West Africans, East Africans, that there is a distinction. My Jamaican neighbor does not identify as an African American. He identifies as Black, and he stated that he doesn't feel that he deserves reparations, even though I have lived next door to him my entire life. Next, I'll just say, remember Reggie Jones Sawyer, you noted the executive summary, which is aligned with what I just explained in my presentation earlier. In the event that this AB 3121 statute does talk about contemporary and present harms, which we all acknowledge it does, it's mandating the task force study and develop reparations proposals on those contemporary harms against a particular group of people. And it says African slaves and their descendants. That's what it says. So yes, we're supposed to develop reparations, the lingering negative effects of slavery as it pertains to a specific group of people. The last thing I want to say about Queen Mother Moore, because I think there's a misunderstanding, Pan-Africanism. Pan-Africanism and a lineage-based approach to reparations is not mutually exclusive. And it's really a shame that people have mascotted Queen Mother Ali Moore as someone who is against a lineage-based proposal when you can literally read her document, 12-page document, where she coins the term descendants of American slaves and champions a lineage-based approach as early as 1962, right? As Kwame Ture, formerly Stokely Carmichael, said, Pan-Africanism is not an ideology, it is a political objective. It's useful when it's useful, and it isn't when it isn't, particularly when people weaponize Pan-Africanism as an ideology, right? To obstruct a statute-driven lead. And the victims are the direct descendants of the enslaved Africans in the United States. So I agree with the motion on the floor, and I think it's apt. It's perfect in that it aligns with the statute as it's written, aligns with the legislative intent of the lead author, Secretary Weber. It's in alignment with the grassroots activists who were part of this process and was at the signing ceremony before the statute was enacted into law by Governor Gavin Newsom. It's in alignment with international law standards, and it's in alignment with the history, the rich history of lineage-based reparations advocacy movement, particularly in the state of California with the Black Panther Party, Queen Mother Moore, and in the United States with Callie House and Paul Robeson, William A. Patterson, a petition against the United States.
Chair Moore, if I can be recognized.
Yes, Member Holder and then Member Tamaki.
Specifically, in my day-to-day as an attorney, I actually bring mass tort cases and class action lawsuits. So we can very much liken this to a mass tort case. And someone actually mentioned Professor Feinberg and his work around the 9/11 mass tort case. He was my professor at NYU Law School. When you're doing a mass tort case, and I'm currently involved in a mass tort case in Southern California against the SoCal Gas Company for the Porter Ranch gas leak. That's one of my cases. When you're doing a mass tort case, you have several buckets. You go in as a lawyer and you say, I'm not going to limit this to the people who were 5 minutes away from the gas leak. There were people who were right next to the gas leak, and there were people who were 5 miles away from the gas leak, but they were all impacted, right? And so even if the impact is on a sliding scale, you still include all of those people as potential recipients of some sort of reparation. You don't just say, I'm only going to include the person who lived right next door to the gas leak. That does not make sense from a legal perspective. You start broad, and then you let the judge limit you. So we need to think about this like a mass tort case with several different buckets of potential recipients, because many people have been harmed. And even if they haven't been harmed at exactly the same level, their harm should be taken into account. We have the harm of the transatlantic slave trade and the Middle Passage. We have the harm of the institution of slavery. We have the harm of the Jim Crow legal segregation. And we have the harm of the post-civil rights apartheid system, which we are currently experiencing now. And anyone who has some proximity to those harms as a person with Black skin needs to be included in the broader class. And then we can narrow it and decide and differentiate in terms of who gets more reparations. But we can't just exclude people who were harmed right off the bat. That's not how it works from a legal perspective. Dr. Gross has her hand up.
Member Gross, you're recognized.
I believe you called on Member Tamaki, so I can go after him.
No, I'll defer to you, Professor Grills. Proceed.
Okay. Thank you. I simply wanted to respond to the example that you provided, Chair Moore, of your Jamaican neighbor. And with all due respect to his particular experience and identification, I think we would do well to perhaps try to move beyond anecdotal examples of things. And that this notion about how Caribbean or African immigrants self-identify in terms of race is a bit more complicated and complex. And so I would encourage you and others to look at Sanders Thompson's article called Socialization to Race, or another article called Black in America Too, that's in Social and Economic Studies, and especially an article written by Oswald Warner in Social and Economic Studies called Black in America, Afro-Caribbean Immigrants. There's a lot more there to when someone says, I'm Black, not African American, and this whole notion about racial identification. Benson also, Janelle Benson's article in Sociological Forum, exploring the racial identities of Black immigrants in the US would be another article I would recommend. But it's a little more complicated than just saying that immigrants will identify as Black, they don't identify as African American.
Thank you. We'll go to Member Tamaki, but before we do that, I want to reference Isabel Wilkerson's cast again, which again, she won a Pulitzer Prize for the book, being the first African American to win the prize for journalism. And in the book, she says, Black immigrants discover that because they look like the people consigned to the lowest caste, the caste system rewards them for doing the opposite of the Europeans. So while white immigrants stand to gain status by becoming Americans, wrote sociologist Philip Kasnitz, by assimilating into the higher status group, Black immigrants may actually lose social status if they lose their cultural distinctiveness. Isabel Wilkerson goes on to say, the caste system encourages Black immigrants to do everything they can to build distance between themselves and the subordinated caste, that being African Americans, they might be taken for. Like everyone else, they are exposed to the corrosive stereotypes of African Americans and may work to make sure that people know that they are not of the group, but are Jamaican, Grenadian, or Ghanaian. Then I'll turn to Todd G. Hamilton's Immigration and the Remaking of Black America. He's a sociologist at Princeton. He demonstrates that immigration from the Caribbean and sub-Saharan Africa is driven by selective, keyword selective, migration, meaning that newcomers from these countries tend to have higher educational attainment and better health than those who stay behind. As a result, they arrive in the US with some advantages over native-born Blacks, and in some cases, even whites. Again, it's not that I'm trying to rely on anecdotal evidence, but many task force members have relied on anecdotal evidence in the past. But I just cited a Pulitzer Prize winning book and a Princeton-trained sociologist that pretty much corroborate what I just said. Member Tamaki, you're recognized.
Thank you. So I'll leave the debate of those issues to the scholars who study this stuff. I think there is room for disagreement on the extent that Black immigrants suffer the same as American descendants of slavery. That's sort of the issue. But to put Professor Lewis on the spot here, what I'm struggling with is any view that those two views are irreconcilable. I'm looking for how you synthesize, both things. And, to use a metaphor of Assemblyman Assemblyman Reggie Jones Sawyer, the polluting factory. In your resolution, Professor Lewis, is there a way to compensate, reward, recognize, acknowledge the injured family living right next to the polluting factory, but then also take action to stop the pollution in the first place? And then to take that metaphor a little bit further, in your resolution, does it allow, and I would categorize this as the cessation of the harm, for folks living beyond right next to the polluting factory, but downstream or downriver or 5 miles away? This is Lisa Holder's point, that we should also be recognizing that harm and doing it in a way that is meaningful. But what I'm struggling to understand is, and I don't see it, as why those views might be irreconcilable. I don't see them as necessarily mutually exclusionary. And unless I'm mistaken in your resolution, I think you actually, in explaining it, talked about in the weeks and the months ahead, it gives the opportunity for the task force to address all these other issues that I've just talked about. So really what I'm asking for is clarification of your resolution in your view.
Sure. Thank you, Don. So to respond to the metaphor of the polluting community, the pollution thing, there's a difference between being the victim of pollution, right? Meaning the experience of encountering pollution, and having your very constitution organized by the very fact of being polluted, meaning your pollution is constitutional to the development of the company, meaning it isn't just something that happens to you, it is what you are. And this is the difference that we're talking about here. And so, someone who enters into a neighborhood that is, a neighborhood that is polluted, right, experiences pollution, but they aren't necessarily defined by the pollution, meaning they haven't had the centuries of identity organized by virtue of being polluted. All right, and I'll leave the metaphor there, right? What I think we have to recognize is that, yes, there is the qualification of anti-Black discrimination that people who have Black skin or who are identified as Black will experience in this country. And that's one thing. But the other thing, and the more important thing, and this is what the motion that I put forward gets at, is that reparations is fundamentally about recognition. In other words, and this kind of goes back to what Member Grills noted as an anecdote by Chair Moore, is how do you actually define yourself? And so what we're talking about is reparations being the opportunity for African Americans, right, who are foundational, to this country, being able to identify themselves and be identified as a discrete group. And what I will say is that I don't think it can be taken for granted that immigrant blacks in the first generation, even the second generation, will identify themselves as belonging to that group. And so there is a distinction. And so the motion was trying to create a category that is recognizable, right? Now, to your point, is that once, and I'll reiterate what I said earlier, is that the entire reparations proposal that we have to put together will account, right, for systemic changes, or will recommend systemic changes that will in fact go on to benefit people who would be considered Black immigrants or descendant of Black immigrants in this country. Right? Because we recognize that they are being polluted, so to speak, but they're being polluted because of, let's call it, the pollutability of African Americans who are descendants of the enslaved in this country. And that's the difference. And so we're talking about reparations as being a continual claim that actually begins in the period of slavery, right? We can talk about Belinda Sutton, who in 1783, right, even before Callie House, is actually asking for reparations from this country, in the same year that this country actually became a proper republic. We're talking about a centuries-long program of reparations of a people trying to recognize themselves. That was a promise of Reconstruction, was being able to recognize oneself as a community, as a distinct community. And so the idea of trying to create this all-encompassing Blackness is actually the reproduction of what we can think of as the manipulation of the category of people who can be exploited, but that category is still always in reference to this foundational group, right, for who the whole apparatus of exploitation was developed around. And so I think the idea of, again, guarding against the repetition of these systemic injuries, meaning police violence against Black people, and I use that term generally, right? The kinds of things that we see as a generalized Black injury, these things will be accounted for in a general reparations program. But when we're talking about identifying, right, a community of eligibility, what we're talking about, right, is that foundational group, the group for which anti-Black violence in this country was orchestrated against, and which the benefits of that anti-Black violence, right, were designed around. Right, and so that's the difference that we're talking about here. And I get that people can get polluted downstream, but it doesn't necessarily account for, you know, what's actually happening at the source of the issue. And that's what we're trying to get at. And this is why I think AB 3121 continues, right, to anchor, you know, to that point with this language of lingering, the lingering effects. So I don't know if that's clarifying for you, Don, but you know, I think
very helpful to me, actually.
The entire proposal will, I believe, account for. But when we're talking about compensation, when we're talking about these direct issues, you know, we're talking about this particular group that I identified in my motion, right? Now, the hope is that once you begin to produce remedies for this group, right, what you have is systemic changes, right? But again, that's not the point of reparations. Reparations is responding to the injuries of this particular group. And reparations has to begin with a principle of recognition, which I get intent and I get legal, what have you, but there's a community who for centuries has been demanding recognition as a people. And that is, I would say quite literally, the one most important thing that they have been denied, right? This was the fear of Reconstruction. Right, in my own work in Oklahoma and Indian Territory, where Black people, right, post-Reconstruction left the South and were able to exercise their autonomy as a discrete group of free people, right, their freedoms were interfered with because of this coherence of their identity. And because with that coherence of identity, they were able to mobilize political will and political resource and economic resource. And this has been the biggest issue in this country's, you know, anti-Black, policy, has been the undermining of the self-determination of African Americans who come out of the principle, the practice of enslavement.
This is Member Holder.
Thank you. Member Holder, you're recognized.
Thank you. Just to jump off on what Dr. Scott Lewis just said, there's mobilization and galvanizing the people. There's a practical side of this. And honestly, I think the legislators on this panel are the most familiar with this practical side. But the practical side is that we have to build consensus, right? That's ultimately what's going to get us over the line. We have to build consensus among the people. And if there are 2.6 million Black people in California, and we just right off the bat just wipe out 30% of that, that is going to create division among the base. We need to galvanize the base, and that is Black people. We can't go into this reparations proposal without having all African Americans in California behind us. And there is no doubt about it that if we just eliminate 30% of that population right off the bat, that's going to create division, that's going to undermine consensus, and that's going to undermine the success of this policy. We have to make sure that we are focusing more on belonging than otherizing in order to build consensus.
Member Holder, I just want to say, if the task force goes with the race-based approach, what I believe you're proposing, that will promote fissures in the Black community as well. Because if you realize, I just wanted to make that clear, either way, there are going to be some unhappy campers. And it's, up to us as a task force to mitigate harm, understanding that under international law, reparations and reparatory justice is supposed to be a victim-led process and a victim-oriented process. So, with the proposal that I believe, an advocate for in terms of a race-based approach, that is going to aggrieve the victims of the institution of slavery, which are the direct descendants of the enslaved people in the United States. To overlook that, I think, is very inappropriate, and it goes against the spirit of the law as written.
That's why you have a special consideration for the descendants.
It doesn't feel like special consideration.
That covers
at all. Go ahead.
That's what covers that issue. You give primacy to that group. That's how you build consensus.
Not what the law says at all. Member Gross, you're recognized.
Yeah, and I was just going to add that we don't know what the lion's share of Black folk in California think about this. What we know is what we see in the chat and who shows up for public comment. And that's one of the reasons that the listening sessions and the survey are going to be so instructive, is that hopefully they will, through their networks, be able to reach a broader cross-section of Black folk who haven't been coming to listening sessions, who can't take time off from work to be in this all day long, who are not members of organized bodies that have a particular perspective. We don't know what the rest of Black California thinks.
Okay. Member Montgomery Step, you had your hand raised?
I did. Oh, you guys can see me. Okay. Hello, everyone. I just want to say a couple of things. One, about the idea that narrowing the scope of the community of eligibility will create divisiveness in the Black community, and I don't think that's wrong, right? I do think that that's certainly a possibility, and it may happen. But I also think it's the way in which we frame this once we make a decision. Now, everyone has autonomy. We're going to vote this up or down, and all of us have to move forward with whatever this body decides. But the way that I think about it, and I'll speak a little bit about just having to, take laws through a certain process. Certainly can't speak about that on the state level, but I'll speak about that just a little bit on the city level. But as far as being divisive, I think it is also the way that we frame it. I think that moving forward with a reparations proposal that keeps the community of eligibility with the descendants of those that experienced that original sin that occurred in the United States sends a message to me than we are moving towards the America that people talk about and have dreamed of. I don't think that it has to be divisive at all. It depends on the way that we talk about it. I see this as a foundation for doing a lot of other things in the state that we need to do to make it equitable and fair. This will not, it's not the be all to end all. I don't see it like that. I don't see any of our work that we do in our respective communities stopping here. Member Holder, we can't hold a candle to what you do and what you have said, but I can almost guarantee you're still going to be in court and you're still going to be fighting Prop 209 issues, whether this proposal goes through or not. So those things will not stop. That advocacy will not stop. But the way that I'm seeing reparations and the way that we define it, I do believe that legally it has to be narrow. I do believe that. I also just, from the political perspective, would love to hear from Member Moore, because the way that I try to approach issues, especially as controversial as this, I'm going to people that may not agree with just the concept in general. If I give them a way out by not making and presenting a legally sound proposal, if I give them a way out, that they will take that way out. And my concern is that if we do not present a proposal that is lineage based, that anything race based there is on its face a legal way out of supporting a proposal like that. So this is very tough. It's a very tough decision. It's why we're here. I don't think that the phrase of special consideration for African Americans or proposals for African Americans was a special consideration is unambiguous. I think we would need to go to the legislative intent. Part of that record has been made here in this meeting and in all of our meetings. So I just wanted just to say those two things. Like, I think that whatever we decide, we have to frame it appropriately so that we keep people on board with what we're doing, because this is not even half the battle. We have to get this through a legislature, and this is very controversial stuff. So thank you for letting me speak.
Thank you, Member Montgomery Stepp. Is there any more discussion on the motion? Is there any more
Madam
discussion
Chair,
on the motion?
Madam Chair, Madam Chair.
Chair Brown, you're recognized. Yes, someone
Madam Chair.
muting me. Vice Chair Brown, you're recognized. Yes, you're recognized.
Hello? Can you hear me?
Vice Chair- Yes, you can speak. Yes, sir.
Are we at the point of ending debate?
I believe we are.
Madam Chair. Well, I'll call for the question, please, ma'am.
Thank you. The question has been called. Parliamentarian Johnson. May you establish a roll call vote on?
Yes, we will vote on the call for the question. We will begin the roll call. Chair Moore. Chair Moore. Vice Chair Brown.
All right, calling for the question. Time for us to vote.
Thank you. Member Bradford. Member Bradford? Member Bradford, you're muted. Oh, you're not. Okay. Excuse me. Member Grills?
No.
Member Holder?
No.
Member Jones Sawyer?
No.
Member Lewis?
Aye.
Member Tamaki?
Abstain.
Member Montgomery Steppe,
Aye.
Member Moore. I'm sorry, Chair Moore.
Aye. I said aye.
I'm sorry, thank you, I didn't hear. And then Member Bradford,
I'm abstaining.
abstain.
Brown?
Did you call Vice Chair Brown?
I did. You voted, sir. Madam Chair, there were 9 members voting. There were 4 ayes, 3 nays, and 2 abstentions.
Thank you. So the motion passes. The question has been
No, it
called.
does not.
Parliamentarian
You
Johnson.
need,
No,
you need
you
5
need
votes.
2/3.
Need 5.
You need
You need 2,
2/3.
yeah, you need 5.
Mhm. So yes.
It failed. I would
So
like to
now
make a
we'll
motion.
discuss the
Yes.
Madam Chair. Madam Chair,
Vice Chair Brown, your
I have a point of order.
Vice Chair Brown, your point of order is recognized.
Each person voted where he or she wanted to vote. And I heard that there was not a vote. Madam Chair, ask the parliamentarian to rule on this.
Right. Yes, you're right.
Beg pardon?
Parliamentarian.
Yes, Madam Chair, to pass a motion to end debate, you need 2/3 of the vote of those voting. You had 9 individuals voting. 2/3 of 9 is 6. You had 4 individuals who voted yay or aye, and you had 3 individuals who voted nay. You did not have 2/3. So the motion, you're correct, it failed. So
Point
you
of
will,
order, Chair Moore.
Member Montgomery Steppe, you're recognized.
Just to be clear, so now we go back into discussion on the motion that's on the floor, correct?
that's correct.
Okay, thank you.
Great. Thank you
Or
for
you can
that.
amend a motion.
Yes.
Or
So we're
introduce
back
a
to
new one altogether.
discussing the motion on the floor. So we're back to discussing the motion on the floor. To the folks who abstained, Member Tamaki, Member Bradford, and others, is there a particular reason why you'd like to state on record the abstention?
Yes.
Member
Do they have
Tamaki,
to?
No,
Do they
I'm
have
asking
to
a
state
question.
that?
They don't have to respond. I'm asking a question. Member Tamaki said he would like to answer it, so I'm giving him the space to do so. Member Tamaki is recognized.
What I'm looking for, what troubled me about the resolution is the exclusion, is the unclarity to me on whether it is exclusionary or not. And that was my concern. Just to be on the record very clearly, as far as the harm class of people that are descendants of American slavery, I'm absolutely in favor of supporting that. But what I also want clarity on is that going forward, for cessation of the harm and guarantees of non-repetition, that the task force will continue to work on those issues as well. And so because of that unclarity, and that was caused by the back and forth between task force members, in which, there was some sharp rebukes going back and forth. It looked to me that some were interpreting that as being more exclusionary only. And my problem is, we're dealing with all of these other issues, particularly the present day ones that continue, but you really can't separate it on the basis of lineage. And again, I throw out the example of criminal justice. And the administration of policies based upon racist policies based upon just anti-Black hatred. At the same time, however, Professor Lewis's remarks that the wellspring of that hatred stems from American slavery. So I really think that has to be acknowledged front and center. I get his point about identity and carving a clear identity that's different from Black immigrants. I think that is also valid. So if somebody could propose an amendment that would clarify that ambiguity,
Madam Chair,
that would help me a
Madam Chair,
lot.
Madam
Vice
Chair.
Chair Brown, you're recognized. Yeah, you're recognized, Vice Chair Brown.
Please, permit me to say.
Vice
It
Chair
is
Brown.
very clear. It's very clear that this is not an either-or matter. However, at this juncture, what we are dealing with, to use the words of the first book that was written by Dr. Martin Luther King, Strides Toward Freedom. That was his autobiography. And I feel that it's an insult to his legacy, his sacrifice. For us to go around in circles as if we do not have the full understanding that if we're going to have any increments of betterments for African Americans in this country, we got to be realistic, practical, and have the full understanding that this measure is about reparations for those who are harmed by shadow of slavery in this country. There can be another day that we come and bring on other measures. That's why you have amendments to the U.S. Constitution. But somebody is maybe suggesting that we do not have the right as Black folks to take the first step, first stride toward dealing with an issue that has lingered in this country far too long. And finally, as I make my comments, I want everybody to understand, please, that when it comes to the diaspora, when it comes to being concerned about the world community, I am one. And I said I'm not being arrogant, I'm just telling the truth. I stood at the top of the list. When I went to Africa, 1964, in Operation Crossroads Africa, I was engaged in doing practical things with sons and daughters of Africa. Even in the United States of America, when it came to the issue of immigration and resettling Blacks here who deserve to be here from Haiti and from Ethiopia and Eritrea. There's not one Black church in America that has resettled over 3,000 refugees. That's Third Baptist Church did. So people are missing the point when they are suggesting we are being divisive and we're not concerned about Black folk. That's not the issue. But we are concerned about the practical step to get something done for African Americans. That's it and no more. None of us can do all things at all times in this earth as human creatures, mortal persons. But I'm saddened that it appears that there is a feeling that we can't take the first step. And finally, again, I say, as a Baptist preacher, why set up ourselves to be involved in a legal battle? And we know very well in the state of California, because of Proposition 209, which has not been repealed, you cannot have race-based activities or legislation. So are we going to be a friend to the enemy? That's the basic question. And I appeal to us, be realistic and show real concern about making the first step toward this issue of reparations in the state of California. Thank you.
Thank you, member. Thank you, Vice Chair Brown. I think the other comments I want to say in terms of guarantees of non-repetition, and I hope that this provides some clarity for folks who abstain, right? But the logic around guarantees of non-repetition as it pertains to the institutions, right? The state harmed direct victims, that being freed African slaves and their descendants. And we have all acknowledged that other groups have incidentally been harmed as a result of that direct harm. So now when we're talking about a lineage-based model, the state must remedy direct victims and their descendants, right? And other groups may very well benefit from a lineage based crafted GNR policy, which is actually a good thing, right? But the logic is that the state directly harmed these direct descendants and their victims, and thus the state must remedy specifically these victims and their descendants. And to the extent that people incidentally benefit, that's fine, but that's not in our purview to study and develop as a reparations task force. And I will say, if we vote outside of the motion that was very well articulated by member Scott Lewis and then properly seconded by member Montgomery Steppe, this task force ceases to be a reparations task force for the institution of slavery. It then becomes a racial equity and identity and racial profiling task force, to which that already exists. It's called the RIPA, and the DOJ, California DOJ, already gives them administrative support. That's a whole other task force. This is a reparations task force for the institution of slavery as it affects the freed African slaves and their descendants, right? I pointed to one of the major points in the statutory provisions, which is that of the apology. It's mandating the task force develop an apology on behalf of the state of California, not for all Black Californians on the basis of race or skin color. It's mandating us draft and craft a policy for freed African slaves and their descendants and nobody else. Now, to the point about Prop 209, I'll just say this. The people of California have spoken. I understand Member Holder was a co-chair of the campaign to bring back affirmative action, race-based policy, but it was a failing campaign. The people of California voted against it. So what are we going to do? Like, continue to, like I said, use the master's tools and continue to use race? Or are we going to be like Isabel Wilkerson and understand that what we're facing in this country and in the state is much deeper than race? And in order to dismantle racism, you have to first address caste. You have to address the caste system that's built on the bones of these African slaves in the United States and their descendants. So that's, again, where I stand. I think the motion on the floor is very well articulated, very well crafted. Again, it's in line with what the statute actually says. It's in line with the lead author of the bill has stated. It's in line with the preeminent legal advice that we've received. There's other factors as well that lean into an understanding that this is supposed to be a pure lineage Reparations Task Force. And again, I'll just say Martin Luther King Jr. Is someone that I look up to. Vice Chair Brown was one of his students, and actually an article was just released a week ago talking about how Vice Chair Brown was one of his students. And in the last book that Martin Luther King Jr. wrote before he was assassinated, called Where Do We Go From Here? Chaos or Community, he says, who are we, African Americans? We're not totally African nor totally Western. We're a true hybrid. We're descendants of slaves, and we're owed reparations for that. Member Bradford, you are recognized.
I think we're just splitting hairs. I just think I'm totally in agreement with all that's just been said, but I just think it could be worded a little bit better. And to use Prop 209 as an example, Prop 16, I should say, was written brilliantly. It was a lousy campaign. And those are two different things. The policy was straight on point because I was involved with that. The campaign was chaotic. And we had people who were running the campaign who never ran a ballot initiative. So, but the intent of Prop 16 is what I'm trying to capture. And not trying to capture here, but it's some validity of what they were trying to do. So I wouldn't use that as an example that where we're trying to go right now with this motion is wrong. So.
No, that wasn't to offend anyone in particular. It's to note the campaign failed. The people of California have spoken.
No, the campaign did fail because it was poorly ran, but it wasn't on the policy why it failed. That's far different a lot of times for folks who haven't been involved in campaigns. You can have an excellent candidate and a lousy campaign. They're not one and the same.
Duly noted. Thank you, Senator Bradford, for that distinction. Is there any other discussion on the motion?
I'm raising my hand.
Member Holder, you're recognized.
What I'm hearing, and I heard this specifically from Member Tamaki, is that we want a motion that is more satisfactory and clear on the issue of whether one group is being excluded or not. So I think the motion needs to be amended. And I think until the motion is amended, people are going to be struggling to vote for it. So I would recommend that we use the benchmark that the economists have already established, which is that there are 2.6 million African Americans in the state of California. And that should be the benchmark for calculating reparations. That way, we are not excluding a large group. And we can make it very clear in this motion that ultimately we want to give primacy to the group descended specifically from U.S. slavery, which is about 200,000 Californians. But at this point in time, for purposes of the scope of work, we're going to use the 2.6 million African American benchmark, which is inclusive of all Black people in California. And so I'm happy.
I have a question.
I'm not done. So with that said, I'm going to put a motion on an amendment to Dr. Scott Lewis's motion that.
I have a question. It's still part of the discussion. So my question is, in the past hearings, Member Holder, you referenced descendants of enslaved Africans as a sliver of the United States and the California population. But then when you noted the community, the economic consultant team presentation, you noted that out of that 2.6 million Black Californians or African American Californians in California, 2 million of those 6 million are descendants of enslaved Africans in the United States. So I want to point out a bit of an inconsistency that I'm hearing over the past couple of hearings, where you have, stated that descendants of enslaved Africans in the United States are a small sliver of the Black community, and therefore the policy shouldn't be tailored specifically to them, but yet the numbers clearly show that descendants of enslaved Africans in the United States, and California included, are actually the majority.
Okay.
So I just want to put that on record.
I'll come to you. And since you're referencing my statement, you're leveraging my statements, let me tell you what I stated. What I said was that the African descendants of enslaved people in the United States who could actually trace their lineage back to a specific ancestor is a very small sliver of people in the United States, for all the reasons that the genealogist talked about. Right? So in terms of being able to say, this is the identity of my enslaved ancestor, there are very few Black people who are going to be able to do that. That was my statement. Okay? Right now we're talking about Californians. And the benchmark that we have received from The Economist is that there are 2.6 million Black Californians. And what I am stating is that that should be the benchmark that they use for purposes of the scope of work. This doesn't have to be a final vote. We are doing this for purposes of giving The Economist benchmarks for their scope of work so they can do their calculations. So let's give them the benchmarks that they say they need. In terms of the community of eligibility, it should include the 2.6 million Black Californians, with an understanding that the 2 million descendants of enslaved people will be getting a special consideration.
Madam Chair, this is Jaretha, the parliamentarian. I just want to point out that was not, we have a motion on the floor that needs to either be amended or it needs to be voted on. But action on that motion needs to take place so that you can move forward. And I don't know if Member Holder was amending the motion. She didn't state it in that form.
No,
Yeah.
she was addressing a question that I asked her before she started to amend the motion.
I'll speak for myself, parliamentarian. I was attempting to amend the motion. Maybe transactionally I didn't do it correctly, but that is my attempt. So maybe you can help me, parliamentarian, craft this amendment to the motion.
Well, if you're amending the motion, we need to have the motion before the House so that we can see what you're changing. Are you seeking to add to what is already written or subtract some language from there? I'm not sure what part of the motion you're seeking to amend.
Okay, we need to pause, right? We'll get to Member Holder shortly where she can do what she'd like in terms of amending the motion, but there's still discussion that needs to happen on the motion that is on the floor. I'd also like to put into record sorry, Parliamentarian Johnson?
Yes, no, she has the floor and she's seeking to amend the motion. So right now she has the right to state what she wants about the motion in terms of amending it. And then you would have to get a second on the amendment, and then you would have to vote on the amendment. If the amendment passes, it changes the motion. If it doesn't pass, you go back to the original motion and vote on that motion. So that makes it all orderly, and that way you can move forward.
Okay, so that said,
Member Holder, you are recognized.
Thank you. That said, I'm going to amend the motion. And the motion is that for purposes of the scope of work for The Economist, the community of eligibility consists of the 2.6 million African Americans in the state of California.
Holder, let me stop you for a moment. It sounds like you're substituting a motion. Are you leaving any part of the language of the first motion in place? Or are you making a motion to substitute. So,
No, I'm leaving part of it in place. The
okay,
part of it that specifies that there will be special consideration for the descendants of.
okay, so
Not
this
what
is
the
really
motion
important.
says.
So it's really important, and I may have to ask Madam Chair if she could get DOJ to assist in that. You need to know what the language is, what it actually states, so that you can do strikeout and amend. Because otherwise, I'm afraid that the members won't know what they're voting on if you're moving to amend. Does that make sense to you? It's
Yeah,
just that
I
they
know
need
the
to know
motion.
what they're voting on.
Parliamentarian Johnson. I know what the
Yes.
motion is. It was moved by, I will state it now.
Okay.
It was moved by Member Scott. Motion is that the community of eligibility be prescribed to to descendants of enslaved Africans in the United States and to the descendants of those who are whose ancestors were African American and were here prior to the 20th century. That's the motion on the floor. So it does sound like Member Holder is trying to substitute the entire motion.
Okay, so she said she was leaving part of it in place. So if that's the case, we just
There
need to know
is
what
the
she's
motion.
striking
Hold
out.
on, Parliamentarian Johnson.
Yes.
There was no reference by Member Scott Lewis of special consideration. So she's trying to amend it by saying, I want to leave special consideration in. That wasn't in the motion to begin with.
Okay.
He said that
That's
the
good.
community of
Okay, it's good. Thank you. That's okay. So you're right.
Africans in the United States. Mhm.
Okay, you're right. If that wasn't there, then she can't strike it out. So we need to know what you're doing, Member Holder, in terms of the specific language.
Yeah, I'm actually trying to write down what the specific language is. It's very hard to just know all of it, but I'm looking at it. So can it be crafted, can it be amended by saying that the community of eligibility be prescribed to the 2.6 million African Americans in the state of California with a recognition that the descendants of enslaved people in the United States will receive a special consideration. Would that be considered an amendment or a changed proposal?
Sounds like a change proposal to me.
Yeah, it's hard for me because I don't have the original language, but it sounds like you struck the first part of the motion. I'm asking if DOJ can put that on the whiteboard or something so that you can see the language so you know what you're striking out. Is that possible?
Parliamentarian Johnson, are you suggesting that we put up some sort of slide for the task members to see that contains the language of the motion that Member Scott Lewis proposed?
Yes. And that way, when the amendments are made, that they know exactly what they're striking and, adding, so we can see what it is, that they're proposing as an amendment.
Okay, just give us one moment.
While we wait, I also just want to put in the record that all the genealogists at the end of their presentation Even the ones who, in their presentation, initially, spoke about the difficulties of a genealogical approach and even spoke against it in some ways in their presentation. At the end of their presentations, when I asked them, what would you go for in terms of lineage or race? They all said lineage. Even Tony Burrows and Dr. Antoinette Harrell and Dr. Robin Semple, who were the ones who showed the most hesitancy about a lineage-based approach. At the end of the day, though, they all said, a lineage-based approach would be the best way to go. And particularly, I think Tony Burrows even cited the statute, AB 3121. Putting that on the record.
And I'd like to put something on the record. With all due respect, that was a false dichotomy. And many of them were hesitant to be hemmed into a false dichotomy. Because I think most of the comments of those who were hesitant was that this is a harm-based issue. But if you're saying that with a gun to my head, I have to choose one or the other, I'll choose lineage. So, I don't really see that as a strong point in rebuttal.
Madam Chair, could you ask?
We need to be careful about the language we use. That's a very inappropriate analogy to me.
Madam Chair.
Parliamentarian.
Yes, could you ask? Thank you. Could you please ask Member Lewis to restate his motion?
Member Scott Lewis, you can restate. Member Scott Lewis, would you like to restate your motion?
Slowly.
Thank you. Okay, thank you so much. Sorry, I'm having trouble with my hello, you want me to restate the motion? Is that what you asked?
Yes, slowly, please.
Okay. So I move that we define the community of eligibility based on lineage determined by an individual being an African American descendant of a chattel enslaved person or the descendant of a free Black person living in the United States prior to the end of the 19th century.
Okay, could you repeat that slowly?
Sure. Would it be helpful if I try and put it in the moderator's chat?
I don't know.
Yes.
DOJ is trying to write. So
yes, that would be very
helpful. Would be helpful.
Okay.
All right.
While he's putting it in the chat, Chair Moore, I'd like to also have something to say on the record based on the.
No, in the chat.
But based
Go ahead,
on
Member Gross, you're right.
Okay, so based on the polling that you did with the witness experts this morning, I wrote down what each of them said and how they responded. And 1, 2, 3, 4, 5 of them said lineage based, but they gave all kinds of caveats and considerations. It wasn't just a clean, yes, lineage is fine. So this just to note that. Actually, 6.
Yeah, there are 6 genealogists. All of them supported lineage with certain, like you said, caveats, but it was really suggestions and recommendations. If we go with the lineage, what are some ways or ways that we could get to that, like negative evidence and other things like that? It wasn't to go against lineage in any way. And then Mike Davis, Kevin Brown, Marcus Champion all supported lineage. Even Greg Carr, who initially in his remarks was pro-race, but then at the end, he was pro-lineage. The only person who was against lineage was Jam Ayuar. So,
It wasn't
okay, now we're,
as clean as you're describing it. I'm sorry. I just disagree.
Member
Member
Lewis,
okay,
were you
thank
able to complete that?
Lewis, did you put that in the chat? Because I don't see
It
it.
is it is in the
I don't
moderator
see it.
chat. I put it
Okay.
in there 2 minutes ago. Do you want me to put it in the general chat? I can do that as well. And I just sent it to Michael Newman as well.
Oh, great.
I don't.
And he
Yeah, I don't
confirmed
see it.
he confirmed receipt. Okay, so you don't see it in the moderator chat.
I have it, and I think we're putting it into a slide to put it up.
Okay.
Okay. So just going back to the amendment, now that we have the language on the screen, what I would suggest is that we modify the first part to say, define the community of eligibility to be consistent with the 2.6 million African Americans in the state of California. With an understanding that there will be special consideration.
Hold on, can you go back to the 2.6 million?
Be consistent with the 2.6 million African Americans in the state of California. With an understanding that there will be special considerations. And then just go to where it says determined and use all the rest of that language. Determined by an individual being an African American descendant of a chattel enslaved person.
Parliamentarian Johnson,
Yes.
I have a question. Is this an amendment? Because it seems as if it's a substantive.
It is substantive, but it is an amendment because the bottom part is the same. So the strikeout is I think it was actually, I'm looking, I can't.
The word lineage.
Define the community of eligibility based on lineage. Okay, so it was based on lineage was stricken. And then the following language was inserted after eligibility to be consistent with the 2.6 million African Americans in the state of California, with an understanding that those will be special, that there will be special considerations determined by the individual. So it is an amendment.
My concern with the amendment is that is now, that's a new motion. You're changing the community, changes the motion.
Well, yes, that's what an amendment, that's correct.
Okay, I just wanted to, just to be clear, just to be clear for the public, the first motion, as articulated by Member Scott Lewis and seconded by Member Montgomery Steppe, is a lineage-based. The second motion, as amended by Member Member Holder, is a race-based standard. Just making that clear.
Okay, now, so you're going to first vote on the amended motion, the amendment. If that fails, you go back to the original. If that passes, then that will be the motion that will have passed.
Madam Parliamentarian, do you need a second to the amendment?
Yes, you do.
Second.
Who was that?
Assembly Member Reggie Jones Sawyer.
Okay, thank you.
Help me understand, could the word lineage still be used in the amended version to determine by individual with lineage to African, to not throw that in there and still capture what you want?
No, Madam Chair. Madam Chair.
And Vice Chair Brown, you're recognized, Vice Chair.
We're going around in circles on this matter. I'm going to be very blunt about it. We're going around in circles. The basic issue has been convoluted. And I hope that we would go back to that motion, we voted up or down. But these specificities about the number of people in the state of California has nothing to do with the generic issue of a lineage-based reparations.
Hello?
The question that was raised was whether or not you could include the phrase based on lineage determined by an individual.
I was going to make a suggestion, line 1, 2, 3, 4, which says special considerations determined by an individual. This is for the maker of the amendment. Can you put special lineage considerations determined by an individual? Or is that
That's fine. I think we can, that makes sense.
Trying to get to a compromise so we can get beyond this.
Would it be, Member Jones Sawyer, would it be special considerations including lineage?
Either way, I'm good. If the people who want to insist on some type of lineage consideration, if they're good with it, I'm ecstatic.
I think that language reads just fine. Special lineage considerations.
My question is, what does it actually do beyond the generic language of the bill, which we are asked to take forward and further specify?
Thank you.
It gives the economists a benchmark. What the economists are saying that they need is a benchmark for purposes of calculations. Now they have their benchmark,
But
2.6.
they had the
nobody knows
benchmark in the
what
first one.
the special means. Nobody knows what the special means. That's very subjective.
That's what was in
That special is already in the legislation.
But the question is, how are you defining African American here?
That's right.
So you still have to do that work.
Special lineage consideration. There you go.
So are you saying that you're for a moment you're using the language of African American, but what you really mean are people who can, who have this lineage, or are you trying to create a two-tier system or something where you are looking at the general population of people who we can consider Black, and then you want to have some kind of special consideration provision for people who can identify themselves or who identify themselves in a lineage model?
And descendants of a free person living in the U.S. prior to the end of the 19th century.
Okay, so if it's both, then my question is that we still have to go and define who are African American here. So what's the determination by which we are assigning this 2.6 million African Americans? What is that based on?
Is that on census? I have a report here that was given.
So people
out.
who just tick Black in the census?
Yeah, and I think we're going to try to pare it down when you get into lineage, when you get into about free persons. That's when we start to get a little more specificity.
I'll just say I think that's incredibly problematic because an article just was released about Native American. In 2020, the notified as Native American and Alaska Native alone on the census was 9.7 million, which and Native Americans have this because they realize their numbers aren't that large, but yet the census allows for self-selection. And so people who are not, in fact, Native American, are not, descendants of indigenous peoples whose lands were stolen, are self-selecting as Native American. And it's taking away from the specific needs of recognized state recognized tribes. That's not the thing. And using that as a benchmark is extremely problematic.
I'm sorry, Madam Chair. Madam Chair, you're cutting in and out. There's something wrong with your internet. I can't make out everything.
Okay. Anyways. Sorry, I didn't mean to impose. Member Scott Lewis?
No, that's fine. Go ahead.
Can you hear me okay?
Yeah, I was trying to get some clarifying terms.
I just wanted to...
Go ahead, please, Chairman.
Did we lose the chair, or am I?
No, I see you and hear you, Member John Sawyer.
I believe the chair just joined again.
Sorry.
There you are.
I apologize. I didn't mean to cut anyone off. I just wanted to say that there was an article that was just released about how people have been self-selecting as Native and Indigenous on the census forms, which is directly harming the Indigenous and Native American population that actually does have lineage to the original peoples of this land and were robbed of their land by colonizers. And so to Member Scott Lewis's point, okay, we're using the census, which is a self-selecting process. That in and of itself as an initial benchmark is problematic in and of itself. I'll just stop there.
If I can say something. I think when you say the 2.6 million African Americans in the state of California, that language is self-evident. You have to have benchmarks at some point. The economists have told us that there are 2.6 million Black people in the state of California. There's no reason to continue to parse